Number 4. Religions that sponsor private schools with married student housing may be required to provide housing for same-sex couples, even if counter to church doctrine, or risk lawsuits over tax exemptions and related benefits. Response. This claim relates to an experience at Yeshiva University in New York. Gay students were eligible for university housing, but their partners were not able to join them because they did not have marriage certificates. It should be noted that Yeshiva University, despite its name, is chartered as a non-sectarian institution, enabling it to receive state and federal funding. The New York court found that Yeshiva was discriminating against the students based on their sexual orientation, not their marital status. The ruling was based on New York City non-discrimination laws. California's existing non-discrimination laws give all registered domestic partners, whether heterosexual or homosexual, the right to equal access to family housing. To date, however, no California private school has been forced to comply with this law. Neither the passage nor the failure of Proposition 8 will have any bearing on the law relating to family student housing in California. The gay marriage problem will not arise at BYU and other church universities because engaging in homosexual activity is a violation of the Honor Code and is a basis for expulsion from the university. These rules will not be overturned merely because California recognizes gay marriage, or any more than they have been because of Massachusetts, Canada, or many European nations that recognize them. Number 5. Ministers who preach against same-sex marriage may be sued for hate speech and risk government fines. It already happened in Canada, a country that legalized gay marriage. In recent California court held that municipal employees may not say traditional marriage or family values because after the same-sex marriage case, it is a hate speech. Response. Of course, anyone can be sued for anything, but no minister has been convicted of a crime in Canada or the United States for preaching against same-sex marriages. The Owens case, on which this statement is based, was brought well before gay marriage was legal in Canada and did not involve a minister, but a private citizen. In that case, a man named Hugh Owens produced bumper stickers and took out an ad that depicted 2 stick figures holding hands, covered by a circle and a slash, along with a reference to a passage in Leviticus that says that a man engaging in homosexual activity shall surely be put to death. Their blood shall be upon them. The lower court ruled that this amounted to hate speech, but the decision was overturned on review. The current Canadian law on hate propaganda excludes any speech if it is spoken during a private conversation or if the person uttering the speech, quote, is attempting in good faith to establish by argument an opinion on a religious subject, close quote. Thus, even ministers who preach against same-sex marriage in Canada have no risk of legal liability or government fines. This would never be an issue in the United States because we have far more liberal freedom of speech and religion laws than does Canada. There have been no hate speech lawsuits in Massachusetts, which has been a gay marriage state for 4 years. The description of the recent California case is another fabrication. This case is Good News Employee Association versus Hicks, which was decided before the Supreme Court legalized gay marriage, and so it, too, has nothing to do with Proposition 8. The plaintiffs in that case were evangelical Christians, not homosexuals, who posted flyers around the offices of the Oakland Community and Economic Development Agency, promoting their Good News Association and calling on those who read the flyer to preserve our workplace with integrity, with respect for the natural family, marriage, and family values. In other words, this group was promoting the idea of ridding their workplace of gay people, a blatantly homophobic message and highly offensive not only to several gay people who work there, but to heterosexual coworkers as well. The supervisors removed the flyers. The Good News people sued, claiming their rights of free speech were violated. The court found that the agency was entitled to eliminate the workplace disruption the flyers were causing, and noted that there were many other ways for this group to promote their message without resorting to such offensive tactics. This case does not hold that municipal employees are prohibited from saying traditional marriage or family values. It has nothing to do with gay marriage or ministers preaching or Proposition 8. Indeed, the court specifically found that there were many other ways for these people to get their message out without disrupting the workplace by creating an atmosphere of persecution. Number 6, it will cost you money. This change in the definition of marriage will bring a cascade of lawsuits, including some already lost. For example, photographers cannot now refuse to photograph gay marriages. Doctors cannot refuse to perform artificial insemination of gays, even given other willing doctors. Even if courts eventually find in favor of a defender of traditional marriage, highly improbable given today's activist judges, think of the money, your money, that will be spent on such legal battles. Response: the argument concerning cost is fallacious and calculated to engender fear. In actuality, the net fiscal effect of Proposition 8 will be an influx of revenue to California because of the anticipated increase in marriage ceremonies and the related boon to the economy. The change in definition of marriage will not bring a cascade of lawsuits because heterosexual and homosexual registered domestic partners already have all the rights of married couples in California. None of the lawsuits alluded to in this paragraph has anything to do with gay marriage. The wedding photographer case was in New Mexico, a state that has no gay marriage law. The medical doctor case was in California, but was based on our existing non-discrimination laws and would not be affected one way or the other by the passage of Proposition 8. In the California case, a medical clinic that provided intrauterine insemination, IUI, to its patients refused to treat one of them because she was a lesbian. California's broad anti-discrimination laws expressly ban discrimination by any business establishment that offers to the public, quote, accommodations, advantages, facilities, privileges, or services, end quote. This statute bans discrimination against individual heterosexuals and homosexuals alike, as well as married people and domestic partners. Therefore, the clinic had the option of either having a doctor on staff who would perform IUI services on a non-discriminatory basis, or cease performing the services at all. Whether we agree with this decision or not, the fact is that the law upon which this ruling was based will not be affected by the passage of Proposition 8, so there is no consequence if the proposition fails. The gratuitous comment concerning activist judges seems to be framed as an appeal to fear and paranoia. In fact, however, today's justices on both the California Supreme Court and the United States Supreme Court can hardly be called activist. 6 of the 7 justices of the California Supreme Court were appointed by Republican governors. 7 of the 9 justices of the United States Supreme Court were appointed by Republican presidents. Most legal scholars would agree that they are moderate to conservative in their learnings and have a healthy respect for constitutional principles. The California Supreme Court has a high reputation throughout the land. A recent study indicates that the decisions are approved of and followed by out-of-state courts far more than are the decisions by any other Supreme Court in the United States. Ronald M. George, the Chief Justice of the California Supreme Court, who wrote the opinion for the majority in the marriage cases, is a judicial moderate who was never considered to be an activist judge. He has an outstanding scholarly background, Princeton and Stanford, and worked as a prosecutor immediately after graduating from law school. He was appointed a Superior Court judge at the early age of 32 by Republican Governor Ronald Reagan. Though young, he quickly gained a reputation as fair-minded, insightful, hardworking, and tough on crime. He was widely praised for his handling of the difficult trial of the Hillside Strangler, Angelo Buono. He rose in the ranks of judges until he was appointed to the California Supreme Court by Republican Governor Pete Wilson. As Justice George considered the marriage cases, the decision weighed heavily on his mind. He remembered a long-ago trip he made with his European immigrant parents through the American South. There, the signs warning "No Negro" or "No Colored" left quite an indelible impression on me, he recalled. As a judicial conservative, it would have been safest for him to vote against the petitioners and avoid the backlash that he knew would come. But, as he put it in an interview with the Los Angeles Times, I think there are times when doing the right thing means not playing it safe. The function of judges is to evaluate cases before them and apply constitutional principles to assure that minorities as well as majorities receive justice. In controversial cases, they are bound to anger some portion of the electorates regardless of how they vote. Their unenviable job is to ignore public opinion and apply the law as they see it. Some decisions are so difficult that reasonable minds can differ. The Supreme Court decision in the marriage case was that sort of decision. Nevertheless, 4 out of the 7 judges on what considered as a moderate conservative court agreed on the verdict that was rendered. This decision cannot be written off as merely the whim of activist judges. Conclusion. In summary, the arguments used in 6 consequences if Proposition 8 fails are false, misleading, and based on faulty logic. Almost every legal case is alluded to is misrepresented. The passage or failure of Proposition 8 will not affect any of the scenarios posed by this document. All of the so-called adverse consequences are illusion. That's what I wanted to share with you today. Enjoy your day.